break, and my understanding is that you only took 1 or 2 classes, and you were given an assignment, and that's where it stopped. So, and then, and part of the previous course outline heavily relied on the previous investment proclamation and investment regulation. So a year later, we really had to change the course outline, which you received today. So you would find there's a bit of a discrepancy between the previous outline and the current outline. But because we have only 6 weeks to go over this course, and as we go through the course objectives, this course would heavily be focusing on allowing you to understand the Ethiopian investment regime and the Ethiopian investment framework. There will be one chapter that will discuss on the global trend, the global investment, the international investment law, but we will not delve too much into that. It would only, considering that you have already, taken 2 classes, and also that, the objective of this course is for you to be able to go out there and advise potential clients on the Ethiopian investment law. So our focus would heavily be on the local law, with a bit of 1 or 2 classes on the international legal regime. So to go over the course outline and the course description, when we were in law school, I remember we took the investment law and the business law course, but much of the course design was not really focused on investment, on business law in general. And I understand that since then there was like a stream of 2 streams of courses, right? There was the public stream and the business stream. Does that happen now still, or has that been merged? It's merged, okay. Yeah, but at least the school has recognized the need that we need lawyers that are trained on investment law, on business law, and on corporate law. This has been because of the fact that, in the last 10, 15 years, if you've seen the trend with the Ethiopian economic development, much of it has been really, focused on foreign direct investment. A lot of our development strategies and economic development programs are really focused on the country's ability to bring in foreign investors into the country. So when these foreign investors come into the country, the first thing they want to know is, so what's the legal environment? How is our investment protected? How is our investment going to be, what are the risks? What happens if there is a dispute? So the first thing they're going to do is, of course, they're going to do first the commercial aspect of it. Does it really make sense to invest in Ethiopia? What are the opportunities? Which sector are we going to invest in? That's the commercial aspect of it. But once they make that commercial decision, they need to materialize that into a viable business initiative. For that, they need lawyers. And so part of that entire professional service that needs to be given to these clients is a really good knowledge of the Ethiopian investment law, the Ethiopian commercial law, and also other, generate other laws like tax laws, customs laws, and all of this. So much of our training when we were in law school was not really geared towards providing this type of services to lawyers, because the demand was not there. Our economic development really did not necessitate the need for lawyers to go out there and provide business advisory services. But that has changed in the last 10 to 15 years. I would say very much in the last 10 years, where the demand for professional services has really gone up, where the demand for lawyers to provide clients, especially foreign clients who have no knowledge of the Ethiopian legal environment, to be able to really guide them through the investment process. So I think this is why this course is so critical for those of you who are interested in business law, for those of you who really want to go out there and provide some transactional advisory, not necessarily litigation. Litigation obviously is one part of the legal services, but there are a lot of other services that does not involve disputes, but that really allow investors to come in and guide them through how to make their investments in Ethiopia, and what are the risks they should look out for, how they should draft their contracts, and an entire due diligence process that needs to be done. So that's why this is a very, very practical course, in a sense that it would really prepare you to go out there and really provide some very concrete advice to investors. So that's also my objective with this course, is to really allow you to really know what the law says, but also understand how you could use that law in advising clients on the ground. That's why much of the focus would be on the local law. And as you would see from the course objectives, we would touch upon the international legal environment very quickly today to some extent, and next week. What are the global trends? Why is international investment law important? And where do we place the Ethiopian current investment law within that global trend, within that global investment regime? So in order to understand that, we will delve on the international legal regime quickly. And also, the second and most important aspect of international investment law, but that also has a very direct impact on the local law, is the bilateral investment treaties. This is a form of international law that is carried out between two countries, two bilateral countries, but also has an applicability in Ethiopia, because as you all know, treaties that are entered into between Ethiopia and any country have the force of law as a domestic law. So in addition to the investment proclamation and regulation, the bilateral investment treaties that Ethiopia has concluded and ratified through Parliament has the same equal force as these local legislation. So we'll be really going through these bilateral investment treaties that Ethiopia has concluded with the context of understanding what if any, for example, investors have any recourse, if at all, through these bilateral investment treaties in addition to the local legislation. And then the next one will, so chapter 1, today and next week, we'll be looking at the global trends, the global investment regime, and following on that with the regulation of investment under bilateral investment treaties. And we will be having a guest lecture, which also somebody Marta. She's also, I understand she's giving you a course currently on another course, the trade law. Yes, and she's also quite an expert on bilateral investment treaties, having been engaged in a lot of that. We'll have the privilege to have her with us next week to talk about the BITs that Ethiopia has signed, what are the variations among these BITs, and what is the trend. So as we will discuss, we'll see that bilateral investment treaties have been quite fashionable for a number of years, but now there is a growing trend that countries are really scaling down on their BITs. Some are terminating them, some are completely abandoning BITs to go for their national laws. So we will place Ethiopia's BIT regime within that global trend, and where are we now and how are we handling it. And then we only have about 6 weeks, so I've tried to really divide those 6 weeks into those that are quite important and critical aspects of investment law. So in the third week, we will have the economic theories of, we will discuss about what are, why so much emphasis on investment? Really what is the role of investment in economic development? What are the economic theories of investment? Do we have domestic investment or do we have international investment? What's the role of capital in making sure that people are employed, technology is transferred, and that people, what's the economic theories that really make us want to have more investment, and what type of environment should we create in order to allow investment to come to the country. So I think it's important to place that within the economic context, and for that we will have one guest lecture that will understand, as we can understand the law and why there is a need to regulate investment in general, because we're having other countries and other people coming in and investment, and there's a need to regulate and strike a balance between those foreign investors and the domestic investors. But really, essentially, why do we even need investment in the first place? So I think that's a very important question to have from economists and people who are in charge of the policy discussions. Law is an instrument of implementing a policy. Law is not a policy on its own. There is a policy of why certain things need to happen in a country, and those are mostly done by policymakers. So lawyers will come in and translate that policy into law. So we will take a bit of a scale back and roll back, and I'll try to understand what's the policy behind the Ethiopian investment. What is the Ethiopian investment policy? Why is it necessary? And how have we managed to translate that policy into law? We will look into that, and we'll have a guest lecture. That will be our third class, and our fourth and fifth class will be the details, the nitty-gritty of the Ethiopian Investment Proclamation, the new proclamation, Investment Proclamation number 1180, 1180, which you will have a copy of today or tomorrow. You can discuss with Rihanna. And the Investment Regulation number 474, which also came out this year, last year. And these are the two key legislations that we will go into and try to understand what are the details that these legislations try to regulate. So two of our classes will deal with that. And finally, chapter 3 and 4 will discuss that. And finally, chapter 5, if we have time, we will try to look into other legislations that are as important to investment as these regulations are. You know, the Investment Proclamation and Investment Regulation are specific laws, it's a specific legislation that specifically tries to regulate how investment is admitted into the country and how it is administered. But it's not the only law that really investors come and deal with. There are a number of other laws that are as important to any investor investing in Ethiopia. So I will try to also go through some of those critical legislations that any investment advisor needs to look into when you're trying to advise clients, for example. So there are a list of laws there. We won't go deep into that, but I'll just simply touch upon them, you know, how those legislations are relevant while providing an investment advisory. So this would be what we will be doing in general. The teaching methodology is also there. As you know, the law school has a policy of continuous assessment. That's what we're going to be doing. We have one assignment, one test, and a final exam that is out of 60. The assignment I'll be giving you next week, which will be due, it's an individual assignment, and it will be due in 2 weeks' time. After 2 weeks, we'll have a mid-test, also out of 20, and then a final exam out of 60. Yes, so this is what we'll be looking at. I will go on and try to discuss the first chapter. If you have any questions here, any comments, I'm open. Anything that you can tell me from what you have learned last year. I know it's been 1 year, and probably it's not possible to keep our memories alive that long, but yeah, still, if you have anything to add, please feel free to intervene at any moment. Okay? The basics. Let's start from the basics. What is investment? How do we define investment, and what does it involve? Right? So investment generally is the movement of tangible or intangible assets from one country to another country at a very basic level. So any investment normally involves through three parties. There is the investor, the individual investor or the corporate investor. There is the invested country, which is normally called the host country. And also there is another third party, which is the country where the investor originates from, which is normally called the home country. So there are these three actors. When you look into investment, these three actors are the main actors that come into play when trying to understand their interaction and the relationship between these three parties. So normally in the context of international investment law, the home country and the host country are two different countries. So the host country would have a different set of laws, and the home country would also have a different set of laws. So what is the interplay between these laws? So which law follows the investor law? So the investor, back in the days, when we think about investment, countries and people have been moving around and investing from one country to another country since a very long time, since the 14th, 15th century. So what kind of laws have they've been regulating? the trading and the investment activities were mostly within European countries among themselves. So it has been quite sort of on equal terms, and it was quite reciprocal in a way that there were not that many issues that were there to really bring any conflict between these countries. So they had their own informal system of trading and investor in which what one country offers was also replicated by the other country. But that's changed. Yeah, I'm going to come to that. And then, what's investment? Going back to that, so it involves these three actors, but how is it translated on the ground? So back in the days, it used to be the capital or the equipment or the resources of one country were transported to another country in order for the second country to be able to produce or use its resources to produce production, either for the consumption of the local population or, as it was usually done in the past, for exports. Normally it was done for export. So typically it was done, it was called as a direct investment where resources, machineries and equipment were moved from one country to another country. But then that's what's called direct investment. So back in the days, when we talk about investments, were the direct investment of one country to another country. But that changed through time, where people did not only take out equipment and machineries and resources from another country, but they started buying shares and bonds and debentures and all these documents that really they use their money to invest in this documentation, but they did not really move any equipment or they did not remove any resources. They simply invested on the shares of those companies. So those are called portfolio investments, whereas the previous ones were typically direct investments. So early on, the early international investment law, as a customary law, only regulated direct investments and not portfolio investments, as it was understood back in the days. So in terms of on the evolution of the concept of international investment law, what it only dealt with was direct investment and not portfolio investment. Whereas nowadays, investment is very, very wide. It includes a lot of, it has a lot of variables within it. But in the previous times when it evolved, the concept evolved, it only dealt with direct investment as it's understood. So like I said, in the 1500s, there was this reciprocal relationship between European countries. But that dramatically changed in the 18th century when colonialism was introduced. As you all know, the colonial imperialist system meant that one country, such as, for example, the Great Britain, will go and literally take over the country. And the relationship was asymmetrical in a sense that the colonized entities had really no control over their legal systems, their business environment. They had really no control. But there was a massive inflow of investment from these colonizers into these countries. So, which meant there were manufacturing plants were introduced, like tea plantations, cotton plantations, huge investments that were directly coming from the Western countries into the colonized nations. So the way that it was dealt with in the 15th century and 16th century was changed, but it was in one way, in a quite asymmetrical way that it was being carried out. And this went on until the early 20th century, until we had the Russian Revolution and the Mexican Revolution, which really changed the way investment was being carried out. But until that point, there was really no, investment was done by the power of the gun. So the colonized nations had no say in how that investment was admitted into the country, how it was administered, and how those investments was being flown out of the country. As you all know, colonialism was a very exploitative system in a way that all the goods and services that were being produced in the colonies were entirely exported back to the industrialized nations. So those local countries really had no say on how that investment was being managed. There were oil companies, plantations, and manufacturing were all made for exports. So international norms that existed prior to that period were mostly developed by non-colonized nations. So anything that, while we have that, the colonial relationship between European countries and Asian and mostly African countries, there was another set of relationship between countries such as the United States and Latin American countries. There was no direct colonial relationship between the US and Latin American countries. However, there was a power dynamics that was really exercised between the US and Latin American countries, meaning the US had a sort of a political, economic dominance over the Latin American countries, and Latin American countries were really under the influence of the US, and their investment relationship to some extent was still developed. So as we will see later on, some of the investment relationship and some of the concepts and principles that came in the 17th and 18th century really sprang out of the relationship between the US and Latin American countries. Because the Latin American countries were, some of them had a pushback, and they were trying to say that, if you want to voluntarily invest in our country, then you need to fulfill these requirements. So as we will see later on, when we look into the real development of international investment law, it came out of the relationship between the US and Latin American countries, and less from those colonial relationships that, for example, Europe had with Africa. And at that time, what really, although it's not specifically called as an investment regulatory regime, but the doctrine of state responsibility, which I think you would be familiar with if you have taken the public international law, which basically says that the doctrine of state responsibility basically says states have the responsibility to protect alien persons and alien property. So this is a well-developed doctrine within international investment law, within international law of nations, and that was sort of broadly interpreted to also include investment law. Although there was no developed law that dealt with international investment law, it is within the doctrine of state responsibility to also protect alien property and alien persons. So that is part of the evolution of international investment law. And so part of the discussions that was coming between the US and Latin American countries was first, the West used to say, so what law should we apply when we apply investment? So they would say, because the investor, it comes from a country, from its own country, for example, from the American investments going into Latin American country, they used to argue that it is only subject to the laws of its own country where it came from American law. It cannot be subject to two different laws, and the law follows the investor and its nationality and not the host country. So this is quite a skewed way of looking at law. Obviously, it's quite beneficial to those countries which are bringing in the capital, and to say that they're only subject to the laws of their home countries. Whereas obviously the countries that are being invested on argue that you are voluntarily coming into our country for your own benefit, not necessarily for our benefits. So investment means you're here to make profits, and therefore we should only be subject to our national laws. And so that argument of the West was not tenable, and it was rejected. And so they came back and said, okay, so if there is a conflict between the local law and the law of the home nation, then the host country should abide by international minimum standards. So the West came up and argued that there is a set of norms in international law that each host country should abide by, and make sure that those minimum standards are met. So that was part of the argument that they made, but then again, that also created another debate. What is this international minimum standard? Who came up with it? And how much of it is really universal? And what are these international minimum standards, and how have they come up with? So the idea then was like, if it is an international law, then it needs to fulfill some of the requirements of an international law, which, as you know, it either has to be embedded in an international treaty, or if we're going to say that it's a customary international law, it either has to come in as an opinion or juris, or it has to be part of a custom, an international custom. So for this, whether this what the West was saying, international minimum standards constituted customary international law or not, was quite debatable at the time. So basically what they were saying is foreign nationals should not be subject to local legislations if those local legislations are inferior or provide less protection than international minimum standards. And national laws should only offer additional protections and not less. And this was quite disingenuous for some Western countries because, international minimum standards, as we all know, or what they call the laws of civilized nations, were quite drafted or quite designed in a way that served the interests of the West. So in a way, it was a roundabout way of saying that the host countries should really apply the laws of the civilized nations, only that they only called it international minimum standards. So there was quite a bit of a pushback from especially Latin American countries. As you see, a famous Argentinian scholar, Carlos Calvo, came up with this doctrine called the Calvo Doctrine, which rejected the idea that there is an existing international minimum standard that states must abide to in order to regulate their investments. And this was in the 1860s, where Calvo came up with the doctrine that said, and then one thing before I go into the Calvo doctrine, the way the interplay between international investment law and investors came about was in the context of expropriation or nationalization of properties. Normally, when we understand investment today, we understand it as those sets of regulations in which investors, what are the minimum requirements that investments need to fulfill, what are the money that they need to put in, how many foreign and local investors do they need to hire, and etc. But back in the days, before the Calvo Doctrine was developed, the context was in the context of expropriation and nationalization. That was the biggest concern of the Western investors that were going into all these different other countries. What happens if our properties are being expropriated? So the Calvo Doctrine, and when you talk about the expropriation, they would say that you would need to fulfill the international minimum standards that are there in order to even first have the right to expropriate. And then even if you have the right to expropriate, what are those things that you need to fulfill to make sure that this is done on the basis of international law? And the Calvo Doctrine basically said that nations didn't, to the extent that nations did not act discriminatorily with foreign investors, to the extent that there was equality among the nationals and the foreigners, then foreigners should abide by the local legislations. This was the fundamental tenet of the Calvo Doctrine, stating that foreign investors should not be subject to any preferential treatment or any beneficial treatment than the nationals of their own country. If they are being treated the same way that the country is treating its own nationals, whether those treatment is above or inferior to international minimum standard, then it does not matter because the foreigners are being treated the same way as the nationals. This would go on and become the theory of the national treatment later on, which is currently a very widely known theory, but it was developed as a resistance from the Latin American countries to this idea of an international minimum standard applying specifically to foreign investors, despite the fact that it did not apply even to national investors. So just to summarize, what does the Calvo Doctrine says? It says that, first of all, the territorial integrity of a state and the sovereignty of a state prevails over any other international minimum standard. Number two, there is the absolute equality between nations, nationals, and foreigners within the Calvo Doctrine. To the extent that foreigners are treated the same way as nationals, then that law should prevail. Number three, foreigners who have voluntarily come into the country of the investor country then should be subject to the laws of the domestic countries. And they should also be subject to the courts where there are disputes And number 4, there should be no interference from the home countries of the investors, which I said earlier. The investors are either individuals or they're corporate entities, but there should be no interference from the home countries of those investors in the internal affairs of the host countries. This was done normally back in the days through diplomatic pressures or through some military pressure, and this should not be done. So the Calvo Doctrine had really these 4 important elements that stated that the right to territorial integrity, the absolute equality of nations, nationalities, and foreigners, that the foreigners being subject to local laws and local courts, and non-interference of home countries in the domestic affairs of host countries. This was quite a powerful pushback at the time from all the pressure that was coming from the Western countries to really subject their own power and might into their investment in these Latin American countries. And then what happened after that was, colonialism was there for 1, 2, 3 centuries. For 200 years in some countries like India, it was there for 300 years. But then the early 20th century really made a drastic change. As you know, the Russian Revolution of the 1917 and the Mexican Revolution of the 1927 was a complete backlash against the imperial system. So one of the ways that this manifested itself was that the nationalization of properties, of private properties of all private citizens. So if we take the example of the Russian Revolution, for example, the state nationalized all private property, both the domestic private property and also the foreign private property. The same thing happened in Mexico in 1927 when there was an agrarian revolution, and then again in Mexico in 1938 there was another revolution that entirely nationalized foreign properties and domestic properties. So at the time, because again there was no international treaty that regulated expropriation or nationalization, countries had to resort to some diplomatic exchanges. So in the case of Mexico, much of the property that was nationalized in the Mexico Revolution was U.S. American investments. So the Americans, what they did was they had to write diplomatic exchanges between the American Foreign Ministry and the Mexican Foreign Ministry on how these nationalized properties were going to be managed. So, and these diplomatic exchanges now became such a powerful exchanges that touched upon what constituted international law, how should we deal with compensation, what are the grounds that expropriation may be rendered, and all of that now became really the source of what today we know as international law on investment. And we see a lot of these formulas, the Calvo Doctrine that I talked about, and the one that I'm going to talk about now, is we see these principles now in a lot of the bilateral investment treaties that many countries have signed, including Ethiopia. And this is how the evolution came about. So following the Mexican Revolution and the U.S. loss of its properties in Mexico, the U.S. Foreign Secretary at the time, he was called Gordon Hall, wrote a letter to the his Mexican counterpart, stating that Mexico should not expropriate. Basically what it says was Mexico had the right to expropriate its properties under its jurisdiction. However, it needs to fulfill some requirements that are recognized by international law. It argued that Secretary Hall argued that expropriation must be done on the basis of 3 principles. First of all, it has to be for a public purpose. There has to be a public element on why expropriation was done. Number 2, compensation has to be paid, and not only compensation has to be paid, but the compensation has to be prompt, it has to be just, and it has to be adequate. So he formulated this sort of formula in which compensation must be paid promptly, justly, and adequately and effectively. So he came up with this formula, and the basis saying that this is a universally accepted norm of international law. So the first exchange of letters took this principle as a way of universal truth in which Mexico needed to abide by it. But then Mexico came back and said, first of all, there is no such universal norm that stated that expropriation has to be followed by any compensation scheme, or not only compensation scheme, and that the compensation also has to be prompt, effective, and adequate. And basically, Mexico rejected the existence of any universal principle on such grounds. And they said that also, that the way that Mexico nationalized these properties was not directed to the foreign American interest, but it was also very much influenced by. Imagine Mexico's argument was quite influenced by the Calvo's doctrine. Calvo articulated his doctrine in the 1860s. And the Mexican Revolution happened almost 100 years later. But it was so influential in the Latin American countries that the letter that the Mexican Foreign Secretary wrote to his American counterpart, he stated that the nationalization was not made in the context of a very discriminatory manner, in a sense that we also nationalize the properties of our own citizens, not only just American citizens. So it was not personal, it was not specific to the American interest. So there is no such thing as a universal truth in that sense. And this was again influenced by the Calvo principle, but what Mexico did said, but we will not object to the idea of providing compensation. However, we will do it on the basis of our own national laws, which has its own set of rules on how compensation should be paid. It has no principles such as that it should be paid promptly or adequately, or it should be effective. So we will agree to the idea that we should be paying compensation, but we will use our own rules to determine how that compensation is paid. So there was a back and forth. These diplomatic exchanges, the letters that were sent, written and exchanged between the Mexicans and the Americans, really came the basis as what today we know, some of the basic rules of international investment law. And then it was this, again, 10 years later, again, Mexico went through another set of nationalization, this time targeted at oil and petroleum companies, American oil and petroleum companies, which triggered another set of diplomatic exchanges between those two countries. And then there was a commission that was set up, and the commission determined how the compensation should be paid. And later on, the compensation issues were settled. But the importance of this is how these principles really developed, or how we see it today. There is the Calvo doctrine that is quite protectionist, that is very nationalistic in a way that really guarding the rights of states to their sovereignty, to their territorial integrity. And then there is the other side of the coin, which is these powerful and very much industrialized nations that are trying to really protect their own interests by first they invoked the rights of the states, the rights of investors to use the laws of their own countries, which was rejected. And then they came back and said, no, okay, then there is the international minimum standards. These are the universal laws. There is the universal principles that states must follow. And that was also rejected. So this, now when we look into all the provisions of some of our laws, what we have in our investment proclamation, and a lot of the BITs Ethiopia signed, you will clearly see where these principles have sprung from and how much of the interplay has managed to bring these principles in. So the Hull formula and the Calvo doctrine are quite a critical aspect of international investment law and how they came about. But there are also, in addition to that, there are also other sources of international law on foreign investment. These are basically quite similar to other sources of international law. primarily there are treaties. Treaties are the main sources of international law. We will discuss later on that there is really no one treaty or convention that deals with international investment law, even to this day. However, there are other treaties, bilateral investment treaties, regional treaties within, for example, within Africa. We have a lot of other treaties that at the Eastern Africa level, at the Southern and at the West Africa level, and other multilateral treaties that deal with investment law. So that's one of the main sources of investment law today. There is international custom that has developed, especially over the last 100 years, through international investment arbitral awards and disputes that have come, and opinionary jurists that have been developed by international jurists. That is also a second source of international investment law, and judicial decisions and general principles of law. The judicial decisions of the International Court of Justice and the Permanent Court of International Justice are also considered as one of the sources of international investment law, where we look into the decisions of these courts on how they have handled investor and state disputes. So on the basis of this, the four principles, what the key principles of international investment law. International investment law. The evolution that we have seen now, currently as we speak today, what are the principles of international investment law that are almost have universal recognition at the moment? So there are four principles. You're probably familiar with these. The first one is the national treatment, which I just discussed. It is a direct translation of the Calvo Doctrine. Basically, by the way, you'll see all these principles in all of the bilateral investment treaties and also in our local legislation. The first one is the national treatment. National treatment basically means that the local legislations or the bilateral investment treaty or the host country that is hosting the investment will treat the foreign investors the same way that it treats its national citizens. Not necessarily the same way or no less favorable way. There will not be any discrimination between foreign investors and national investors, and they are treated both on a way that is not any less favorable to the foreigners. Of course, any rule has an exception. There are some exceptions to the national treatment law. We'll come and see next week on what these exceptions are under the Ethiopian bilateral investment treaties. But generally, the exceptions are, first of all, the national treatment only applies after the investment is made. It's a post-investment requirement. Meaning, when investments are trying to come into the country, they're not accorded the same national treatment as the nationals. So, for example, an example is, our current law, for example, it does not allow some foreigners to come in and invest in certain sectors: banking, insurance, retail services. Some sectors are closed for foreign investors, as you know. If we were to follow the national treatment principle pre-investment or before they come into the country, then we would need to allow all foreigners to invest in every sector that is also allowed for locals. So, but because the national treatment is typically applicable to post-investment stage, this treatment, then we're not required under international law to give the same treatment to foreigners when they come in. But once they come in, provided that they abide by the local legislation, once they come in, then they're treated the same way as we treat our national investors. So, for example, tax laws. There are no tax laws that are specifically applicable to foreigners, and that are specifically applicable to domestic investors. So, post-investment stage, you accord the same level of treatment to foreigners as you do to your nationals. And also, for all that will be applicable for all four principles, there are some exceptions or to provide less favorable terms. But this has to be justified on the grounds of public interest, public health, and other qualifications that each state may have on its own law. That's principle number one. Principle number two, most favored nation principle. Also, this one is also similar to the national treatment, except that it says that the most favored nations treatment treats foreigners, foreign investors of different countries the same way in the host country. So this basically says you cannot treat two different foreign investors that have come into your country in a different way. So all foreigners, be it from Asia or the US or the Europe, are treated the same way as other foreigners. So this is also protecting other nationals from really being encroached on their rights using other means. For example, if I have a bilateral investment treaty with Kenya that offers a favorable, say incentives or a favorable environment, whereas we don't have I don't have a bilateral investment treaty with the US, then the MFN principle says that you cannot offer a more favorable treatment or incentive to Kenya because you have the bilateral investment treaty with Kenya, whereas you don't have one with Americans. So all foreigners that are invested in that country should be treated the same way. That's principle number two. Number three, fair and equitable. This is one principle that's quite controversial. It says that all investors in a country should be treated fairly and they should be treated equitably. From the face of it, no one would have an objection of having these principles in your laws. Of course, fairness is good. Of course, equity is good. Every country would seek to achieve this type of, fairness and equitable environment, right? But the issue comes in what does fair mean? How do we define equitability? How do we understand fairness? Because these are quite sensitive issues, especially when you look into it from the perspective of quite industrialized countries that have achieved their universal or minimum standards of living and health and prosperity for their nations, and they're coming into the country that are less developed, very much behind the development curve, and they're trying to achieve a lot of basic minimum services to their countries. And when you bring these two into play and put them on the table and say, no, this is not fair and this is not equitable, who gets to define what's fair? And how do we understand fairness from the perspective of the investor and the host country? So this is a very, very disputable and controversial issue, and it has been tested in practice. In a lot of the investor and state investor disputes that we have seen in the last 50 years between African countries and Western countries at the International Center for Dispute Settlement, Western countries have invoked the fairness and equitable standard to claim that they have been treated unfairly, they have been treated unequitably within their investments in those host countries. And most of these decisions have been seen to really be against the interests of the African countries. And now we will see when we talk about the trends within the bilateral investment treaty, we will see that a lot of countries have dropped this principle from their treaties because they've been misused. They've been used to target African countries on the basis of the Western understanding of fairness and equitability. But then again, it's generally still a recognized principle. And some countries, because of the problem that have arose in the last 50 years, have gone on to define what fairness and equitability means. Yes, there will be fairness and equitable treatment of foreigners within the laws, but fairness means this, and they define it in their laws, or they annex a commentary on their laws on how countries should interpret fairness and equitability. The last and the fourth principle, recognized principle of international investment law, is expropriation and compensation, which I discussed early on. Now it's a given, it's almost a given that all states have the right to expropriate. It's within sovereignty and territorial integrity of states, to expropriate properties to the extent that its four principles are fulfilled. Number one, it's for public purpose. Again, this is heavily drawn on the Calvo principle that was developed in the 1860s by the very resistant Latin American countries. First of all, it must be made for public purpose. There has to be a public reason behind it. It should not be discriminatory. The measure should be non-discriminatory. There is a due process embedded in the expropriation scheme. That it's done according to law. It's not arbitrary. There are written laws that have, that regulate how expropriation may be made. And finally, there is a compensation. The compensation scheme, as we discussed earlier, the Hull formula says that compensation has to be prompt, adequate, and effective. There are some countries that have adopted that, especially Western countries. They have this formula. Other countries have also adopted that some of the same formula, and others have changed it a bit. And some have completely not even included the Hull formula, but to a largest extent, it is understood that compensation should be effective and adequate, and it depends on how each specific country defines their compensation scheme. So basically, these four principles are now embedded in a lot of the regional agreements that you see at different continents, bilateral investment treaties, and you will also see them in a lot of investment legislations in each country. The way that these principles are embedded is different. Some of them may have all four principles included. Some may have only national treatment, MNFN treatment only. Most of the legislations have expropriation and compensation. It's almost universal. But the way the other principles are embedded in each legislation is different. Some have fair and equitable, some fair and equitability. Some only have national and fair and equitability. So it depends on the policy of each country to decide how it wants to treat investors when it chooses this to reflect these principles on its national legislation or even on the bilateral investment treaties. Okay, so these are the principles, and then just to go quickly, as I mentioned earlier, that there is really no one international legislation that regulates international investment law. Currently, there is no convention that is approved or accepted by many countries that we can really pinpoint and say that this is the legislation that regulates international investment law. But this does not mean that the efforts were not there. There have been many, many efforts to really come up with one legislation or convention that would really regulate international investment law. Let me quickly go through those efforts. Like I said before, before the revolutions of the early 20th century, there was these diplomatic exchanges, and there was this customary international law that were ad hoc in a way, arbitrarily and applied in an ad hoc manner. But then after the Second World War, we had the UN, the supranational body of world nations that was trying to regulate international peace, international law and order, and also international trade and investment. So right after the end of the Second World War in 1945, when the World War ended, the sentiment at that time was there was a wave of decolonization across the world. Countries were getting, especially former colonies, were getting back their own sovereignty, and they were getting all their political power back. And the main part of that entire decolonization process was the ability to take ownership of the investments and the properties that existed in those countries. So these were primarily oil companies that used to be held by colonial powers, and other manufacturing plants, industrial plants, and tea plantations, coffee plantations. All of those properties that used to be owned by the colonizers are now back to the country. So there was this very nationalistic and protectionist sentiment within these newly independent countries to really take charge of their properties. So when the UN was formed after the Second World the Second World War in 1947, 2 years later, the Havana conference was a conference was set up by these developing nations in Havana, Cuba, to regulate how trade and employment and investment may be regulated. And so they tried to come up with a sort of a document, an agreement on how their relationship is going to be regulated going forward. But it was so controversial, it was abandoned. It did not go anywhere because the US heavily criticized the process and the way that the developing nations were trying to regulate the relationship, and when the US abandoned, the whole effort was abandoned. And after the UN came in, this was prior, the Havana conference was prior to the UN, but after the UN came in, the UN, the system of the UN is every country is represented, right? So when you look at it numerically, in numbers, the developing countries or the newly independent countries had quite a numerical majority over the developed nations. So when the discussions were being held at the General Assembly, all these discussions were heavily geared towards protectionist policies for developing countries. So a lot of the discussions did not bring about any consensus. On the one hand, developing countries wanted to really passionately pursue the Calvo Doctrine, stating that that our rights and our sovereignty to our borders, to our national resources should be ensured, and we should only protect investors if our national laws require it to be. Whereas on the other hand, the developing countries, much of them who have lost their their properties and their investments through a number of nationalizations and expropriation, were saying that no, we should apply international investment law and protect foreign investors. So these debates were being held at the UN, and a consensus was very hard to reach. And any effort to come up with a convention or a treaty that would regulate these investments really went on a deadlock. They did not go anywhere. The best that they were able to achieve was they came up with a general resolution, a General Assembly Resolution 1803, which was quite a sort of a soft law. It does not have the power of a convention or a treaty. I mean, states are not, or General Assembly members are not required to abide by it. But the best they could do was they came up with a resolution that recognized, first of all, the territorial integrity and sovereignty of states. They recognized, this was the early one of the earliest sources of the UN General Assembly resolution that recognized states' rights to territorial integrity. Again, a reflection of the Calvo Doctrine, which happened 100 years ago. Prior to that, the UN also recognized the rights of states to expropriate, but however, to provide compensation, they defined it as an appropriate compensation. They did not follow the whole formula. Sort of the compromise that was reached is that states should provide appropriate compensation for any expropriation. And also, this was also pushed by the developing countries. At the UN, they said that for any dispute that occurs between the investors and the host countries, the exhaustion of local remedies should be pursued. So as a matter of first instance, as a matter of first forum, the local court should be pursued, and not international arbitration or not international court of justice. The exhaustion of local remedies should be pursued first, giving the possibility for both the nationals and internationals remedy. It does not close off the possibility that investors could go on and bring their claim at the international level, but they need to exhaust the local remedies first. So that was the one. And then what came up in 1965 was the Convention on the Settlement of Investment Disputes, what we call them the ICSID Convention. This is still a very important convention to date. It's not an investment convention. It's a very specific and narrow convention that deals with investment disputes. So basically, when all the efforts at the UN and other regional is instruments were falling apart. The World Bank, which had a very strong interest in making sure that Western investments were protected, came up with a sort of a compromise. And they said, we will host a center for investment disputes that only deals with investment disputes between investor countries and states, between investor and state, and we will facilitate. And they came up with this, the Convention on the Settlement of Investment Disputes that deals only with the procedural aspect of investment disputes. This is quite narrow. Again, it's not a broad convention that deals with international investment law or any of these principles. It was also sold by the World Bank and the IMF and all these Western institutions as an instrument to attract investment. So if you're seen to be a party to the ICSID convention, then because it boosts investor confidence, because if investors know that the country which they're investing in is a member of the ICSID convention, and that they would have, for any dispute, they would have recourse to the ICSID Center. The ICSID Center was hosted by the World Bank. It was based in Washington, D.C., and any dispute that the investors in the host country had would be directly brought to the center. So it was sold as an investment attraction strategy by these countries, saying that investors would be more likely to invest in your country if you if you sign on to the convention. So the convention was passed in 1965, and of course Latin American countries, quite the skeptic that they are, they were not enthusiastic to the idea of signing on this convention, whereas the African countries, almost majority of them signed onto these agreements, which is what we will see 40, 50 years later. So many of the disputes that are brought into the ICSID Center are mostly African countries, and now there's sort of a backlash now in which a lot of African countries, some of them are terminating the convention, withdrawing from the convention, stating that it's been unfairly used against African countries. But when the law was coming up, because they bought into the idea that these are freshly decolonized countries, there's a competition for international investment, so they need to sign on this law this convention that will help them attract those investments on their own terms. And they were not also very worried about the idea of the territorial integrity and the sovereignty issues, because this convention only dealt with procedural matters. But as we will see later on, and especially next week we will discuss, ICSID was used as a roundabout way by foreign investors to develop rules of international investment law. So a lot of the decisions that came out of the ICSID disputes are cited as a main source of international law, in which the principles that we see here, especially the fair and equitable treatment principles, were expounded by disputes that were treated at the ICSID level. So, and then there are a lot of controversy and criticism from the developing countries that ICSID was used as a tool to really decide on most of the ICSID decisions were favorable to the investors, heavily investor friendly, at the expense of the host country, and this was used to disadvantage these countries. But when it came on in the 1965, it was seen as an alternative to a convention that was not able to come to regulate international foreign investment. The 1960s to 1980s were again really a period of uncertainty, so to say, because there was the international economic movement at the time was divided between the communist bloc and then the liberal bloc, and really states did not really know where they belonged in that place. And developing countries within the UN were mostly leading efforts to come up with laws that should regulate foreign investment. But then again, due to the economic hardship brought on by the socialist policies, most developing countries started abandoning their protectionist policies and sought to calm to foreign investment. So there was this confusion in the 1960s and and 80s, especially from the developed countries. They were not really trying to, there was the majority of the developing countries within the UN that were trying to come up with the protectionist policies, but at the same time, the socialist policies at the time, which most of countries were following the 70s and the 80s, brought on some very serious economic hardships in these countries. So they were trying to balance out these protectionist policies with the economic hardships they were facing in their own countries. And those interplays were not, could not allow for any meaningful international treaty to come up with. So that, however, changed in 1919 with, with the fall of the Berlin Wall and, the end of communism that brought about, and the triumph of the Western liberal ideology that brought about a number of liberalization processes. So in the early 1990s was a period in which countries were opening up their economies. There was a number of liberalization processes that were going, and this really ended the whole confusion between within the developed countries, especially in since the 1940s, since the UN came up. And the triumph of the liberal policies meant that foreign investment was used as one way to bring about liberal policies in these countries. So early 1990s, after the fall of communism, a lot of African countries especially started opening up their economies. Foreign investment was being encouraged. All the protectionist policies of the 1950s and 1960s was abandoned. Bilateral investment treaties, they started rushing for bilateral investment treaties to be able to attract investment. Most of them have already signed on to the Exit Convention. And the whole dynamics of the international investment regime changed in the 1990s. But then, in parallel, during this period, when economies, especially economies of the developing countries were opening up, a lot of the capital and the investment was coming, obviously, from the Western countries. And when the liberalization efforts were opened up, a lot of the opportunities that were created by this liberalization was being exploited by Western countries. So Western countries, again, started to come up with saying, okay, we need guidelines now, or we need laws that would regulate our investors who are investing heavily into this newly opened up economies. So we need to come up with guidelines or laws that will, again, regulate this environment. So the Europeans came up with one guideline in 1998 called the OECD guidelines that they could regulate with. Again, this did not go very well. First, they initially designed it in the 1970s. Again, tried to amend it 3-4 times, and in 1998 they came up with a multilateral agreement on investment. It was called a multilateral agreement on investment, in which countries were the OECD countries, these are 43 countries, mostly European countries, and some Asian countries. Investors from these countries that were investing in other countries had to abide by these rules. But that didn't go anywhere. In the 1990s, late 1990s, there was a very strong pushback from NGO groups, human rights organizations, and environmental groups that stated that these guidelines were entirely skewed towards investors. They did not take into account human rights violations of multinational corporations. They did not take into account environmental frameworks. And because of this heavy criticism, this guideline was abandoned. And then the WTO came about. In the early 2001, the World Trade Organization was again set up. The World Trade Organization, you probably would learn about it in the trade class. It's mostly an organization that deals with international trade and international trade in general. Obviously, investment is part of the trade, but it did not really deal with investment on its own. So it came up with a number of agreements that tries to deal with removing barriers to international trade and any rules or restrictions that are applicable that created trade distortions. So the WTO's mandate was quite specific in a sense that it only dealt with trade, but then there were discussions that we need to bring about investment into the discussions. And so there was some, at the Doha round of the WTO's negotiations in 2001, there was a discussion to have, again, an investment specific agreement or an international investment law within the auspices of the WTO. But again, this did not go anywhere. The idea of adopting an international treaty regulating foreign investment was once again removed from the WTO discussions because there could not be an agreement on how this should be dealt with. So what we have today is still no international law that regulates international investment law. There's no one single convention that authoritatively regulates international investment law. Of course, there have been efforts, many efforts at international level, so nothing has come about. That, in parallel to that, there are, while the international discussion and dispute and all the controversy was going on, some countries have had regional efforts to come up with their own regional investment framework, right? So the first one was what we call NAFTA. It's the North American Financial and Trade Agreement. This deals with Canada, the US, and Mexico. So they had their own investment, sort of an investment treaty that dealt with how investment is being regulated. Then also there was another one that the Asian countries had that regulates Asian investment flow within the Asian countries. And there are also some efforts within the African countries. So in Africa specifically, quite relevant for Ethiopia was the COMESA, the CONTO agreement signed between the COMESA countries, which Ethiopia is a member. It's not directly an investment agreement, but it has quite a number of the principles of international investment law, the CONTO agreement. And also within Africa, there are other agreements. So East Africa, the East African countries, Ethiopia is not part of them, but the East African countries also have a sort of an investment agreement that deals with investment of their own. These are Kenya, Uganda, Tanzania, Rwanda, and Burundi. Within the East African community, they've come up with an investment agreement. SADC has their own. SADC actually is the South African regional bloc. They actually have a quite advanced model investment law that has a model bilateral investment law in which each Southern African country should abide by, and which also have a detailed commentary in it on how countries should abide by these laws when they sign on to the BITs, and also when they draft their national legislation. Similarly, the ECOWAS, Western African countries, have their own investment, sort of an investment legislation that deals with the West African countries. So there are these, sort of scattered initiatives at the international and regional level that try to regulate international investment law. And quite recently, in 2016, the African Union tried to really bring together all these different regional instruments into one, and there are efforts now to come up with a Pan-African Investment Code. So the Pan-African Investment Code has been drafted, and the draft is available online. I think I have linked it in the course outline, but you can also Google it, you can find it. A draft investment code has been drafted by the AU that is intended to replace all the regional instruments. And once countries are part of this investment code, then that would also be applicable. It has been going on for the last 4 or 5 years. But one concern with this is now, the Continental Free Trade Agreement, which Ethiopia has signed onto, and now has become effective, basically opens up all countries to all trade and investment. So in a way, all these regional instruments might become irrelevant if there's a free movement of goods and services. And part of the ACFTA is to come up with an investment protocol. So the latest information that I have is now within the ACFTA regime, there are efforts to translate the draft investment code, the draft Pan-African Investment Code, into a protocol of the ACFTA, an investment protocol within the ACFTA. So in any way, be it the Pan-African Investment Code or the investment Investment Protocol, the ACFTA, there would be one investment treaty or regional treaty that would regulate investment within the African continent, either the Investment Protocol. If that comes into play, then that would be one legislation that will go on and regulate investment within the African continent. At the international level, that remains to be seen. But the African level would come into play first. Okay, so this is the last part. Next class we will discuss about, so this is generally what the global trend is and how investment is regulated globally and how it's regulated regionally. So next week we'll discuss about regulation of investment under the bilateral investment treaties. So because of this deadlock within the international community, the international community's inability to come up with one investment law, what has proliferated over the last years has been bilateral investment treaties. Currently, I think the latest number is about 3,500 or more than 3,000 bilateral investment treaties are signed globally. In Africa, there are more than 500 bilateral investment treaties. In Ethiopia itself, I think the latest number is about 35 bilateral investment treaties Ethiopia have signed with 35 countries. So these are a very important source of law on investment, so we will deal with them next week. You will find the copies of these investment treaties online. I think I've linked the link on the course outline. So it would be good if you could read a sample of them. Not all of them are the same. There's many variation among the bilateral investment treaties, but we will deal with them next week. What are the main common principles that Ethiopia has signed on to? What are the responsibilities? What are the differences? Has there been any trend or difference in the last few years of the new investment treaties that we have signed on to? So we will discuss all of that next week, and we will also have Marta on board to join us